Welcome to the Kids Caught in the Middle video series. I'm Liisa Speaker, owner of the Speaker Law Firm and author of the book, Kids Caught in the Middle, How Families Are Harmed When Judges Don't Follow the Law. Today's episode is about Chapter 2 of the book, Initial Custody Orders, and what goes wrong in those initial custody proceedings. Now, those initial custody proceedings very often deal with two parents who are divorcing each other, but they can also be with two unmarried parents who need to have a custody order to govern their lives. Before the trial judge enters a custody order, even on a temporary basis, the court must find who the child has an established custodial environment with and what's in the child's best interest. Now, for established custodial environment, it's important to remember that it's about who the child looks to for guidance, discipline, necessities of life, and comfort. And it's also important to remember to make findings of fact on each of those elements based on the evidence in the record. It's really not helpful when a judge just concludes that the established custodial environment with both parents without explaining why. Another important thing is that if the judge misses its finding, it fails to make a finding on the established custodial environment, that creates a big problem because we won't ever know if the burden of proof was properly applied. So failing to make a finding on the established custodial environment usually results in reversal on appeal, but that doesn't help anybody because it's just putting the parties back in front of the court again when it could have been resolved off the beginning. And as far as the burden of proof, if the court doesn't state the proper finding on the established custodial environment, it most likely will apply the wrong burden of proof. It may apply clear and convincing evidence standard when it should have applied the preponderance standard. So there's lots of different appeals and issues that come up regarding the established custodial environment. And then remember, when you move to the best interest analysis, the judge has to make findings on each and every one of the 12 best interest factors, not just the ones that the judge thinks is appropriate for the case, even if it means the judge is just saying that neither parent is favored on a particular best interest factor. In Chapter 2 of the book, I cover a lot of problem areas that I see frequently in family law cases. For example, the entry of an ex parte or temporary order and how that potentially impacts the rest of the case, how the trial court has to consider each child's best interest individually and not just lump the children together. What happens when the Court of Appeals reverses the trial court's custody decision, and more importantly regarding that, the trial judge's obligation to consider up-to-date evidence at that point, and other issues such as the child's reasonable preference and the trial court's use of the in-camera interview to find out that preference. So to learn more about the book or how we can make changes to our family court system to avoid a lot of the problems that I've seen, click on the link below, and I'll see you with the next video on Chapter 3.